All right. Welcome, everybody, to today's ERA Live. Thanks for being here. Our esteemed presenters today are Adam Glazer and Adam Maxwell, attorneys at SFBBG, who will present legal updates for reps in the greater industry. Before we get started, audience members, please be sure that your devices are muted. If you would like to ask a question, please type them in the chat box and we will try to get to your questions as time allows. This session is being recorded. We will post the recording on our website and our YouTube channel within 24 hours of this session ending. Walter Tobin, ERA's CEO, will now get the session started. So, Walter, take it away.
Hi, thanks very much, Claire. I am remote, so I apologize. I will be shutting my camera off. I'm not driving. I'm just sitting in a car. We really want to welcome once again both Adam and Adam, who are, the guidelines of ERA, keep us on the straight and narrow, and really help keep our members up to date on all the latest legal goings on in our industry. We're very excited to have them present some updates on some legal issues that are important not only to reps, but to manufacturers and distributors. So without further ado, introduce Adam and Adam. Take it away.
Thank you, Walter and Claire. It's very good to be with you. We always enjoy spending time with ERA. I'll share with you, if you all agree to keep this as a attorney-client privilege. Adam and I sometimes work with other rep associations, but ERA is far and away our favorite. So don't tell anybody else, but I want you to know how happy we are to be with you folks today. We're going to cover a subject matter, if I can handle the computer correctly, which is never a sure bet. Then we are going to talk about legal updates for reps and the industry. The subject matter that we're going to cover today in particular involves succession planning and contract termination issues, which are going to be led off by the lesser of the two Adams. And then we'll get to the more important material dealing with changes and updates to the law on non-competes, federal overtime rules, Transparency Act, and there may even be a hint of the so-called Big Beautiful Bill in there for discussion as well. For those of you who know me, you know that I spend most of my time drafting or negotiating rep agreements or chasing down unpaid commissions. However, more and more we are involved in succession planning. It seems like this is a big area for reps in all industries, and with some of the changes in the law, I think we had to talk about these issues. Why these topics necessarily? I will tell you that other than calls that we get about commission recovery, these are probably the most significant questions that we get. We get a lot of calls, a lot of emails about succession planning, about transition issues, usually issues involving termination. So we're going to talk about termination of agreements today. We're going to talk about some non-compete rules which apply throughout the industry. Manufacturers, reps, all should be interested in changes to the non-compete and how they apply state to state. There are some tweaks to the overtime pay rules in the new administration, and we'll give you maybe a closing word on the Corporate Transparency Act as well. So beginning with succession planning, the subject matter is important to really everybody. Obviously, owners of rep firms are the ones who will begin the process. But the rep firms and their family members are all concerned about something like this when it comes time to talk about transitioning a rep firm. In a way, it's a lot like estate planning. You do have to make these arrangements in advance. You don't want to wait until it's too late or until you're up against some sort of deadline. You want to think about the succession planning ahead of time. Your employees are interested in this matter as well. They want to know what's going to happen to the rep firm. Your partners on the manufacturing side are very interested in the future of their representative partners. So this is something that has universal appeal. And of course, your customers as well. Your big customers want to make sure they're going to continue to be well taken care of by your successor or successors. So it's important to everybody to make sure that succession planning, is covered. Now, you got to know that an entire webinar could be devoted to succession planning. This is a huge subject. And sometimes we do spend entire programs on this topic, but I'm going to try and get through it very quickly, covering some of the important materials, but not everything. So the first question that's always gets asked when we talk about estate planning, is how much? How much is it going to cost? How much am I going to pay, depending on which side you're on? And what we always tell folks is really the question that you should be asking is how much of it will you keep? And from the buyer's perspective, how much of it can be written off because it's a significant expense. So we look at some of the factors that go into this. And there are several different variables that will affect setting the price. If we're only talking about commission income, if you have any buy-sell inventory, some reps are still buy-sell reps, and we look at other things like gross profit. If you have a concentration of principals rather than principals spread out, perhaps through the territory or sometimes throughout the country, if there is a concentration of customers, do you have a big collection of customers who are located geographically diverse areas, or is it just a handful of customers all in the same industry who are well known to each other? These have effects on the purchase price. What about in the business and the industry and, of course, the economy? Obviously, with the tariffs that have taken place, although that's a separate webinar, that too has had an impact on the value of rep firms. Look, it's a lot easier on the manufacturing side. When a manufacturer wants to talk about succession, there's usually, assuming we're not selling to another manufacturer, but within the company, there are usually officers, right? There are vice presidents, there are managers who are in a position to move up, and it doesn't involve a top to bottom reorganization. Not so with a smaller rep firm, where you really do have to concentrate on things like each of these various items to make sure, since it's going to be sold, the whole thing, you got to make sure that all of these various factors are at least considered. Does the rep own real estate? Do you own the building that your agency is in? Does anybody still go to buildings anymore? Or is it all a remote operation? And a lot of folks will want to use an appraiser. There are various appraisers who get involved in this. Some of them come to the ERA conference. Sometimes you hear people talk about this. Folks who are capable of doing a more scientific evaluation of the rep firm, and they perform a different kind of valuation. So all of these factors can help determine what the purchase price is going to be. But then you got to ask yourself a more basic question. While succession planning is important to a company's present and future, I mean, it does protect against unexpected occurrences such as an owner's illness or a death. And having a succession plan in place is certainly important not only to the owners of the firm, but to the other members of the family. I mean, consider that, of course, rep agencies can even get terminated by their manufacturers because they do not have a succession plan in place that will assure the continuity of the agency's business, or at least an effective succession plan that will do that. Manufacturers want to know that they have a long-term partner, not that this is going to, that one illness or one retirement is going to affect their ability to continue in the sales channel. So you do keep all the manufacturers included in your plans. And of course, you got to consider that key employees can sometimes leave an agency if they don't know that they are part of the agency's future. If they've been identified as a potential future owner, having a plan in place and making sure that it's not a secret is very effective for all of the folks who are involved here. But then you have to consider, well, what are you actually, when you get around to making the transition, what are you actually selling and what are you actually buying? After all, rep firms don't have any inventory typically, or equipment, or long-term contracts, or receivables, the things that normally a buyer pays good money for. Instead, what a rep agency sale involves typically is the concept of goodwill, the income stream from the agency. This is where you have to get into very specific information that reflects the history of your agency and how well you've done over time. Now, who's going to buy the agency? There are really 3 or 4 who are the most likely candidates to succeed you as the purchaser of the agency. The most logical, of course, is if you own a piece of it, your co-owner will buy you out at the appropriate time and take your share of the agency and become the sole owner, or acquire a larger share if there's more than 2 of the owners. But the most common purchaser of a rep agency are the key employees. One or more of the employees will likely want to succeed you, and you will negotiate a deal that works for both you and for the prospective purchaser, the current employee. Other candidates are family members, if you have them, who are interested in the business. Some may already be working for your agency, and maybe you're going to be very generous in terms of the funding for the acquisition. But family members or close friends who are familiar with and who appreciate the value of your agency are also potential purchasers of the business. And of course, there are outsiders. You can merge with another rep firm. There are other acquisition partners, more and more. I know you are familiar already. You see venture capital coming into the industries. And perhaps there is a venture capitalist out there who wants to take over the agency. Who knows what they're going to do with it? But there are more and more instances where we see that happening. But in terms of how to proceed, once you identify who the purchaser is, and you're going to move forward with the sale, there are certain key steps, and this is really the heart of the discussion about this today. Obviously, we have the concept of due diligence. We have the concept of determining the purchase price, which we've discussed a little bit. How is the transaction going to be structured? And then the necessary legal documents and the terms that have to outline the process. Now, due diligence initially requires typically a non-disclosure agreement. Most of you have signed NDAs with your manufacturers. Manufacturers have signed them with their other business partners. But they're very important when it comes to a sale, because neither party, after all, wants the world to know about these discussions. Buyers don't typically want to encourage other suitors, so you don't want the information that are out there about the business being for sale in the first instance. And certainly sellers don't want others on the field to understand all of their financial information. So an NDA is pretty important for both sides. There are other protections that can be included in these agreements, and you have to be careful how they're drawn up. They have to be drawn up properly. But one important inclusion for an NDA is to have an appropriate remedy in case it's violated, and that often takes the form of injunctive relief. Typically, you'll want to have the ability to obtain an injunction, meaning going into court and having a judge order that the violation of the due diligence provision be enforced. And a judge would be prepared upon a proper showing to enjoin or to order the improper use or disclosure of your confidential information by the other party to stop. So these are very important terms. Adam and I are currently involved in a lawsuit where a seller drafted his own non-disclosure agreement. And unfortunately, that didn't properly protect the seller from the buyer using the disclosed information. So essentially, the buyer was able to steal the seller's business because the NDA wasn't drafted up properly. So that's something we're pursuing now in court. Something that obviously would have been avoidable. All right, so one more quick discussion about the purchase price. It used to be that the purchase price was determined by the financials of the seller, and there was a rule of thumb that we would typically use that valued the agency at 100% of 1 year's commissions. That old rule may or may not be sufficient today for valuing a business. The value can change from anywhere from 75% to 150%, depending on many variables. Buyers want to see rep agreements. They want to see the commissions that you've been paid. They want to see what the termination clauses in the agreements say. They want to know about your post-termination rights as they're set out in the agreements. And we're going to talk more about post-termination rights in a minute. Does the seller need the consent of the manufacturers for the sale of the agency? That's a very common provision in rep agreements. As you know, manufacturers want to know that you're not going to just willy-nilly sell your rep firm to somebody they're not comfortable with, or perhaps to somebody who they've had a previous relationship with that didn't go well. And a lot of manufacturers will make sure that they have provisions in your rep agreements that say they get to sign off on something like this, or else the agreement terminates in the event you're going to sell your rep firm. So it's not uncommon to see sellers require their consent in order for a new purchaser to stay on as the rep, and that's obviously a very valuable part of the purchase. So you have to work with the manufacturer partners on something like this. agreements can be terminated if if there's a change in ownership or management without their approval. Then we talked about some of these other items that I wanted to mention again: value of leases, of inventory, of any real estate, but also of trademarks that the rep firm may have. The telephone numbers could be very valuable. Websites that are frequently trafficked can have value. And of course, the structure of the contracts that you have with your principals can all add value to the business. One other thing: employee non-compete agreements can be valuable assets. That is to say, you as the rep firm owner with your employees, if you know that they can't compete against you, that can be a valuable asset. But as my partner Adam Maxwell is going to discuss in a few minutes, those are not legal in every state. Those may not be enforceable in every state, the non-compete agreements. So we'll get to that. You may also want to consider, are you selling a particularly hot product right now? Are the trends in your favor as the seller? If you can show that obviously business is projected to boom because of the hot market that you're in, that can also help increase the value of the rep firm. So setting the purchase price it can be done in different ways. There is the concept, and it's a somewhat dated concept, of a fixed purchase price, and that typically will favor the seller of the business. For example, 100% of the average of the last 3 years of commissions. That's a fixed purchase price. And that can be paid out over time. But as the buyer of a rep firm, the buyer may not want to get stuck to that kind of formula because that's 3 years in the past, and who knows what's going to happen next year. And the buyer could end up getting burned if there's a sales price that is too high, and if the sales that are coming in won't fairly fund the agency's cash flow from the continuing operations. Typically, if it's an employee or a business partner who's taking over the agency, they're not sitting on a pile of cash, and you're going to get paid from future operations of the business. And that usually works because both sides have an interest in seeing the rep firm continue to succeed. So it's important that the price be reasonable. And that sometimes is done by setting not just a fixed price, but a fixed price with some adjustments to help the buyer in the event the business deteriorates after the sale. There's an opportunity then for the buyer to pay less, or for the agreement to be structured so that the payout period is longer, so the buyer can sustain the business. And remember, as the seller, since you're getting paid out from the cash flow, it's important to you as well that the buyer do well and the buyer continues to stick around, because you may have a deal that says you're going to get paid 100% as a fixed price, but if the business sours and the business closes, you're not going to get paid. So the fairest approach is probably today to use a variable price. And when I say variable price, I mean a purchase price that's based on the agency's ongoing sales activity and income. And with this approach, both the buyer and the seller have risk and benefit in it. For example, if you have an agreement to pay out over 7 years, and I know some of you think 7 years is a long time, but it's really not so long. Depending on the age of the buyer, I suppose. But you could have a 5-year or 7-year agreement where in a 7-year instance, say 15% of gross commissions are paid each year to the seller. And that way, over 7 years, the seller would get paid 105%. So there's obviously a benefit to the seller in that instance. But the buyer also gets some downside protection, because we're not talking about having to pay it all out regardless. It's a 7-year term and it's paid out from the gross commissions. So it usually works out to protect both sides. You can also use a cap and a floor with the numbers to make sure that it's fair to everybody and that it's going to work out. So then the question becomes how to structure the transaction. The two basic approaches, as many of you already know, are an asset sale or a stock sale. And the tax considerations affect either approach. A C corporation, as you all know, and its owners would get double taxed when selling assets. So I don't know how too many rep firms today that are still C corporations, but there are some. S corporations and LLCs do not get double taxed. We often recommend using a consulting agreement, that is to keep the seller involved and around and participating in the future of the rep firm, not only for the health of the rep firm, but it also helps the buyer reduce taxes, because the seller would pay the tax on consulting fees as ordinary income. So it's a benefit to both sides. It also keeps the seller around to continue offering expertise during the transition period. Lastly, on this section, proceeding with the sale, there are any number of legal documents that would be used to make sure this works effectively for the succession planning, and they can be quite extensive, and they often start with a non-binding letter of intent. And most of you have done these before, and you're familiar with what an LOI looks like. It'll set out the basic terms of stock or the asset purchase, and it'll set out the price and when it is to be paid. And it's not binding, so everybody can continue to work this through and make sure we're comfortable with it before we actually proceed to a binding contract, a sale contract. One last thing that you should consider here is the concept of having life insurance. Many sales reps who are in a position to sell their rep firms, let me put this delicately, may not be in their 30s. So it may be something that you want to consider as the seller of the firm. You may want to have protection by taking out life insurance on the buyer. That may not be immediately intuitive, but just in case anything happens to the buyer, the seller's not going to get paid. So it may be worthwhile to have life insurance taken out on the buyer that at least is in place until such time as the seller of the agency is fully paid. So proper succession and the resulting transactions involve preparing many documents and consideration of many related business and tax issues. So you want to consider all of that when it comes to succession planning. That is a short summary of succession planning. There's obviously going to be a number of questions about this. We can certainly take questions at the end. I don't know whether they're coming through in the chat room or in the chat box or not, but we can come back to these, or you can feel free to call Adam or me after this and we can talk more about succession planning. For now, I want to talk about the strength of the contracts, because a rep agency's value is tied into the strength of the contracts, as we discussed. And termination and transition issues are important to everybody, to manufacturers and to sales reps. Take a look at this provision from a contract. I wasn't involved. I'll tell you right up front, in this, I didn't prepare the contract. I didn't edit the contract. This came to my desk after there was already a dispute in place. But here is a rep contract that I really like because of the change that was made by hand. Again, I take no credit for this. This wasn't my advice. This is what the rep did. There was an agreement that was sent to the rep, which with somewhat standard language, and I'm talking about section B here, where it says the company and the rep shall have the right to terminate the agreement without cause upon 30 days notice. Unfortunately, I don't like that agreement. It's not a fair agreement. Not 30 days is much too short unless it's a rep with virtually no experience with the principal. But the principal sent out this agreement, and this led to an entire suit, an entire dispute that went all the way to verdict, because the sales rep, before signing the agreement, as you can see, crossed out the word without, changed it unilaterally to with, to change the entire essence of the agreement. Now, with that term, the rep could only be terminated with cause. And you see those are the sales rep's initials next to the term with. I think she even made the circle big enough. I'm not sure about this, but I think she made the circle big enough so the principal could then initial next to her, which, as you can see, was never done. But what happened was the agreement was changed. It was sent back to the manufacturer with this change in it. The red arrow wasn't there. I've added that for you. And it was sent back to the manufacturer, and the manufacturer received it and then signed the agreement and sent it back. And of course, as you can see, the issue in the case was, is this binding with the change that was made by one party, or is it binding, or is the original agreement in force because the manufacturer never accepted the change? Well, I will, I'll ruin it for you, and I won't keep you in suspense. The ultimate finding here was that because the manufacturer received it back with this change, and then signed it and sent it back, that was an acceptance of the change. The manufacturer was charged with knowledge of this change and with having accepted it. And all of a sudden, this became a very strong sales rep agreement because there was no ability to terminate without cause, just the ability here to terminate with cause on 30 days notice. And as a result, the judgment was a very significant judgment in the sales rep's favor. So the lesson here on both sides is to make sure you read, negotiate, and agree upon all of the terms in the contract. But I suspect that for purposes of succession planning, this agreement would have driven both the buyer and the seller nuts because they wouldn't have known which term was effective. But obviously, the way it was interpreted, it became much more effective, much more successful for the sales rep in this case. I'm going to show you another termination clause. This deals with rights upon termination, meaning post-termination commission rights. And here's one that I want you to consider, because what this agreement says, this provision of the agreement says that upon termination of the agreement, the rep gets paid, but it gets paid post-termination commissions, which have been agreed to, but the company, in its sole discretion, can cancel the representative's entitlement to any portion of the commissions after 30 days if the company determines in fairness that some of it should get paid to another rep. So this is an agreement where the rep thought he had negotiated and was going to receive some strong post-termination commission language. But there was a provision like this that essentially meant that the company, in its sole discretion, could take that away, ostensibly to pay another sales rep the money, but the rep who signed this agreement, of course, would never be in a position to protect that or to know about that. So I highlight this only because I think it's important that as we consider updating our knowledge of all of these provisions, you got to be careful that what you carefully negotiate with one hand as the sales rep isn't taken away with the other hand with a provision like this that says, yeah, we agreed to pay you generous post-termination commissions, but in a separate paragraph, we have the right to take those away should we decide that it's appropriate. And if you look at this provision, unfortunately, that's what it provides. So I don't think this is necessarily something that is represents a bad faith effort. I think the manufacturer in this case simply wanted to reserve its rights and wanted to protect itself in the future. But this is something that it clearly needed to be understood by both sides ahead of time. I'm not sure it was, and I put it up here again because if you are in a position where you're trying to determine the value of your business, for succession planning purposes, and you see a provision like this, how do you value the contract? How do you know whether you have a contract with post-termination rights or whether the manufacturer is going to point to this provision and say we can do what we want after 30 days? So it's another tricky situation for both sides. So I'm going to close by showing you what is in the ERA specimen contract, which is reflective of the industry standard. It shows here a true compromise effort on this section for both manufacturers and reps who are familiar with this, with the terms that are used in most rep contracts. What sales reps want to see in termination provisions is typically the right to continue getting paid for the work that they generated before they were terminated or before they terminated their relationship. And there is a certain sense of fairness to that. If the rep is responsible for the sales continuing to come in, let's assume it's a commodity for a minute, and the sales continue to come in, then the general thinking is that there shouldn't be a windfall to the manufacturer by eliminating the sales rep's commission. Instead, the rep should continue to get paid. But manufacturers say, wait a minute, what I'm supposed to pay you in perpetuity? You're going to get paid forever? You're going to get paid, longer than I'm working at the business? That's not going to fly. So there was some effort here in the ERA specimen contract to arrive at a compromise. And what you see here reflected is the language that says that reps should get paid for the 3 years following termination in the event that they have procured orders that continue to come in. And so this is this I think is in addition to being a compromise position, it also does enable upon a sale of a rep agency for a agency to be valued with some certainty, looking at language like this. Okay, so with that, I am going to turn this over now to much better hands, and Adam is going to bring you up to date on some changes in the law, starting with restrictive covenants. Adam?
Perfect. Thanks, Adam. So yeah, like Adam said, I'm going to cover three topics. This will be a little bit abbreviated because, as Adam mentioned, we give presentations on these topics, presentations that can go a full hour on each topic, and you could workshop one of these topics for several hours over the course of an afternoon. We've done that before. So we're kind of covering the most common issues associated with these particular topics. So I'm going to start with non-competes. We're going to turn to some recent developments and some of the basics and fundamentals for federal overtime. And then we are going to turn to a brief update on the Corporate Transparency Act. And I'm going to share my screen, Adam, so you don't have to
okay, good.
with me.
All right, I'm going to stop it.
And I'm going to try and float my head in the corner here. I hope that's working. All right. So just to set the table here, when we talk about non-competes, it's important to remember that these are just one piece of a larger family of restrictive covenants that are used. These are the contractual tools that are used to protect the business interests. So besides the non-compete, which we'll focus on today, we also often see non-solicitation, non-disclosure agreements. Adam mentioned that in connection with the sales of businesses. They're also used elsewhere, obviously, just to protect business interests, and not in connection with the sale, just in the ordinary course of business, non-disparagement clauses. And these are used across the industry in terms of across the electronics industry in terms of with principals, with customers, with other reps and agencies, and of course with employees of those entities. So, and even with territory considerations and exclusivity. So that's sort of what we're going to dig into. But like I said, we're going to start with non-competes. And so that's the focus today. So just to give you a little bit of history or recent history on the trends here, early January of 2023, so 2.5 years ago now, the Federal Trade Commission announced a proposed rule to essentially ban all non-competes for workers post-termination. There were some limited exceptions, but what was the topic of the day and sort of on everyone's mind was the possibility that non-competes would not be effective anymore for the reason that the FTC stated that it violates the Federal Trade Commission Act and suppresses wages and stifles innovation. Okay, so that was their announcement of a proposed nationwide ban. That's a pretty dramatic policy shift. Obviously, there's been the use of non-competes is a tale as old as time, I think. And so that rule, the FTC rule, is still tied up in legal and political challenges, and obviously the political environment has changed. But what that did 2.5 years ago is it created momentum and set sort of a new baseline for, and I'm trying to see here, looks like this was cut off a little. There we go. All right. It set a baseline for policymakers and courts to think how they think and how they approach enforceability of non-competes. So the FTC proposal didn't just sit in Washington and wait to be decided whether it was going to be implemented or not. It sort of generated this ripple effect, and states individually jumped in with their own laws, the legislatures. The courts began scrutinizing cases a little bit more closely, a little bit differently, and employers started rethinking their approach to protecting their own business interests. So at the state level, in the wake of the FTC's proposal, states began, like I said, to bring on these statutes to either re-examine or tighten their own laws with respect to non-competes. Some states, so you have three categories. Some states implemented complete bans or almost complete bans for all intents and purposes. Other states implemented partial restrictions, and then yet other states made some minor tweaks with very little restrictions, but still upgraded the statutes to allow for example, the recovery of attorney's fees if you challenge and lose a lawsuit on the enforceability of a non-compete. So some of those states that now have complete bans, and I think the first state to do that after the FTC announcement in 2023 was Minnesota. California has had a complete ban for a while. North Dakota, Oklahoma, Wyoming. These are all states that have essentially complete or total or near total bans on non-competes. Like I said, the second category is with partial restrictions. Many states permit non-competes but impose limitations. And these are not the standard limitations like, oh, it has to be reasonable. Those are actually the states with very little restrictions. But these partial restrictions are restrictions that are sometimes based on salary thresholds. So in order to be subject to a non-compete, or in order for a non-compete to be enforceable, the employee or the worker has to make a certain dollar amount per year. Or it could be based on job duties or geographic scope, or just the duration of the non-compete. And so courts often assess whether the agreement is reasonable and necessary to protect legitimate business interests. That is often the language that is included in these type of partial restriction statutes. So states like Illinois, Washington, Oregon, Colorado, Massachusetts have recently enacted limited enforceability statutes, like I said, often with salary thresholds or notice requirements. The rest of the states essentially have very little restriction. And like I said, what that means is that in most circumstances, the non-compete agreement has to be what's called reasonable. It requires that they're reasonable. That, of course, is not defined. It is defined by courts. So courts typically uphold non-competes if they, for example, protect trade secrets, protect client relationships, protect proprietary information. That is the type of restriction that a court will generally look at enforcing, assuming that all of the components are reasonable. And what I mean by all of the components, we'll get into in just a moment. But suffice it to say that the trend currently in the current legal landscape of this is that courts are much more skeptical of broad non-compete restrictions. And what that means is judges are more and more willing to strike down non-competes as unenforceable or unlawful, which sort of echoes and reflects the FTC's framing that they can suppress wages and innovation. So that's all to say that the current landscape is on a state-by-state basis. There is no federal rule. There is no federal ban about that. With the current administration, we do not expect the FTC to proceed vigorously and pursue a federal ban. So it's likely going to remain with the states for the foreseeable future. And so that makes things a little bit complicated in terms of drafting and enforcing non-competes that you think otherwise might be enforceable in different states and in different territories. So some of the more interesting developments we see are on the state-by-state basis. Even if states are, like I said, even if they're not imposing additional restrictions, they're passing laws that shift power to the employee. So by, for example, requiring additional notice before a non-compete, 14 days, for example, you have time, 14 days to consider a non-compete before signing it. Statutes that require the party proposing the non-compete to advise that the employee should consult an attorney in writing. And if these things are not met, those non-competes may not be enforceable. There is a sort of an increased risk associated with unenforceability of restraints because contracts, as Adam mentioned in the sale context, obviously add value when they're clear and you know what the obligations and the liabilities are. But when those contracts are unenforceable or when there's uncertainty about unenforceability, it introduces a little bit of risk and a little bit of unknown. So now we're seeing different sectors banning non-competes. Does not necessarily relate to the electronics industry, but we are seeing, for example, physicians and healthcare workers, those sectors, different states banning those. Indiana most recently did that July 1st, 2025, last month. So still a lot of activity at the state by state level, at the legislature, and it's definitely something to keep your eye on and your ears open to. Some of the practical implications of this phenomenon and this sort of change in the environment is that many companies are shifting away from traditional non-competes. And instead, they're using non-solicitations, for example, which are typically not subject to the same type of scrutiny by courts. Or companies are using stronger confidentiality protections, stronger trade secret protections to avoid this sort of regulatory risk, the uncertainty associated with enforceability of non-competes. We're also seeing a little bit of a revival of other somewhat creative mechanisms that are being used, like forfeiture for competition provisions, which typically exact some type of penalty for competition. So just to differentiate, a forfeiture for competition provision, a forfeiture for competition provision essentially imposes a penalty for competition. So the choice is the policy behind it is the choice is the employees to make, but they may forfeit a significant amount of money for compensating, for competing. They may forfeit already earned compensation, for example. And those are typically enforceable. They're not typically subject to reasonableness scrutiny by the courts. And so you have to be very careful because these types of agreements are coming back and you're seeing them, and they look very much like non-compete agreements, but they are not non-compete agreements. So I talked a little bit about the reasonableness of the non-competes, and this is the general rule in the majority of states. Obviously, there are differences that we talked about with statutes, but in order for a non-compete agreement to be enforceable, generally speaking, it has to be reasonable with respect to the time. So the period of months or years, the geographic scope, as well as the prohibited or prescribed conduct. And it depends on the state and other circumstances what reasonableness means. With respect to a geographic scope, for example, it's common to use territories, but that's not always enforceable. Even non-competes that use, for example, radius restrictions, like a mile radius per, not 1 mile, but like 100-mile radius from the location that a rep works, for example, or 5 miles from every customer location. Not always enforceable. It really depends. It depends on the impact. How big of a size is this? How many businesses does it cover? Does it restrain the individual's ability to make a living? With respect to prescribed time and duration is sort of self-explanatory, but there are differences, obviously, as to what is reasonable. Generally speaking, what I've seen, if you're looking at less than 2 years, a court is usually not finding that is unreasonable as a matter of law. If you get beyond 2 years, you're starting to call into question what that is. But again, it depends on the circumstances. There is something with respect to the prescribed activity being reasonable. There's something called the janitor rule. So that is just shorthand. A shorthand way that we describe this is that it's drafted so broadly that, for example, I'm a sales rep. I cannot go to a competitor in any capacity, even as a janitor. That's the janitor rule. It was drafted so broadly it prevents someone from taking any job at a competitor, even as a clerical, administrative, a receptionist, or a janitor. So sometimes individuals sign these agreements. Those usually are found to be overly broad with respect to the prohibited activity. And then courts also, generally speaking, will impose a requirement that these restrictions, these non-compete restrictions, and the different pieces of the non-compete be narrowly tailored to protect what's called a legitimate business interest. So what is a legitimate business interest? It is not to just prevent competition. It is genuinely to protect trade secrets, company confidential information, customer relationships, or specialized training and things of the sort. So simply trying to avoid competition is not going to cut it. And those are likely not enforceable. That's a very high level of overtime of non-compete. We're going to move on to some of the federal overtime updates. And we're in a unique time with the current administration where the past administration and the agencies under the past administration were enforcing and sort of taking aggressive stances with respect to enforcement actions and rulemaking. And so some of these are, I'll give you a little bit of the history so that you know what prompted the developments and where we're at currently. So with respect to overtime, in April of 2024, so only about a year and a half ago, a year and a quarter ago, the Department of Labor, who's responsible for overtime regulations, finalized a rule to raise the thresholds for salaries in 2 stages to introduce essentially a triennial, every 3-year automatic update mechanism to make it such that non-exempt employees had to make a certain dollar amount of salary in order to be exempt. And so this was going to cause a lot of workers. The bottom line is it was going to cause a lot of workers who were previously exempt from overtime, who were not entitled to overtime, to become non-exempt and eligible for overtime pay for everything over 40 hours. Now, as of November of 2024, a federal court issued an injunction, blocked that increase, and so that's on pause, right? We're not expecting, again, the Department of Labor to push forward with this increase to the salary thresholds for workers and exemptions from overtime in the near term. But the reason we're talking about this today is because, and talking about overtime in particular, is because there are other, as Adam mentioned, big, beautiful developments. And one of those is with the One Big Beautiful Bill, which included a no tax on overtime provision. That exempts from tax up to $12,500 of overtime for single filers or $25,000 for joint filers. A pretty big deal. People are pretty excited about that. No tax on overtime retroactively begins January 1, 2025. It's going to remain in place through 2028, and it may be renewed as well. Time will tell on that. But the reason we're talking about this is because we talk about the effect of awareness. People are, workers especially, exempt workers and non-exempt workers are much more aware of this. It affects the money going into their pockets, and you can be sure that because overtime is not going to be taxed, more workers are looking into this and seeking guidance on this with respect to whether they're properly classified as employees or independent contractors, for example, and whether employees are properly classified as exempt or not exempt. So the perception of extra take-home pay has led more employees to scrutinize their classification. And you see a lot of inquiries in that regard. So that is with respect to whether they are properly classified as an employee, like I said, or an independent contractor, and whether, if they are an employee, whether they're exempt or non-exempt and entitled to overtime. We expect misclassification claims to be on the rise. These are often triggered and have historically been triggered by confusion over overtime eligibility. We saw an uptick in claims associated with even the entities preparing for the Department of Labor final rule, increasing the salary thresholds. Companies were doing independent audits and independent internal audits. and finding that they had misclassification issues. And that does not remain a secret in an organization for very long, unfortunately. Briefly, what law governs overtime? It's the FLSA, Fair Labor Standards Act, that governs wage and hour standards. Covered employers have several obligations under the FLSA. I'm going to speed through these a little bit because I want to leave a few minutes for questions, but the FLSA ensures that non-exempt employees are paid both minimum wage and overtime for all hours worked in excess of 40 in a work week. It also requires that overtime be calculated correctly, which can be difficult in a commission environment, and it mandates certain record-keeping requirements. State and local law, I have to mention, is a little bit beyond the scope of this presentation. It does vary. A lot of states follow the FLSA, the federal law, but typically states will impose more stringent requirements with respect to overtime and with respect to record keeping especially. So we'll start with who gets overtime pay, who's entitled to overtime. The FLSA says that all employees are deemed non-exempt and therefore entitled to overtime pay for all hours worked over 40 unless they qualify for an exemption. So the presumption is a worker is entitled to overtime pay unless they qualify for an exemption. Employers, the entity, bears the burden of showing that employees are properly classified. So all employees who work more than 40 hours and who are not exempt are entitled to overtime. Overtime is 1.5 times the regular rate of pay for every hour worked over 40 in a work week. It's important to get the classification of workers correct with respect to being an employee as opposed to an independent contractor. That impacts a variety of different considerations, state and federal tax, benefits offerings, triggers all kinds of employment laws, discrimination, and of course, overtime. So it's important to get that right, and it's also important to get the exemption from overtime right. That's a common thing in this industry. People generally know outside salespeople are exempt from overtime. There are numerous other exemptions. The most common are what's called the white collar exemptions, and these can be combined, but they're executive, administrative, and professional employees, the EAP exemptions, and a variety of sales roles not entitled to overtime. Record keeping, suffice to say that there are some stringent record keeping requirements associated with it. The longest time period for record keeping under the FLSA with respect to payroll records, agreements, total dollar volume, and some basic employment earnings and records, 3 years. You have to keep those records. So it is a little bit different for exempt versus non-exempt employees. There are more records that have to be kept by the business for non-exempt or hourly employees, or employees, I shouldn't say hourly, employees who are entitled to overtime. But we won't go through those. There's essentially 13 categories of information. Some of them are pretty standard. There are no real surprises there, but it all relates to pay and eligibility for overtime. All right. Briefly, with respect to the Corporate Transparency Act, effective January 1, 2024, the Corporate Transparency Act became a federal law, required essentially all businesses, with very few exceptions, LLCs, corporations, partnerships, all other entities that are registered with any Secretary of State, to report their beneficial ownership to FinCEN. FinCEN is a bureau of the Department of Treasury that collects and analyzes information about financial transactions in order to combat money laundering, essentially, terrorist financing and other financial crimes. Those deadlines were they were on again, off again, almost entirely through 2024. FinCEN extended the reporting requirement to deadline to March of 2025. And then as the deadline loomed, FinCEN announced that it will not issue fines or penalties. And then, of course, they very shortly after the deadline issued an internal final rule that effectively only requires foreign entities to that are registered to do business to report their beneficial ownership. So nothing going on new in that regard. And for domestic corporations and entities, reporting is no longer required. We're continuing to monitor developments in that regard, but do not expect any changes for the foreseeable future on the corporate transparency reporting requirements. So I know I covered those three topics pretty quickly. We're going to take some questions. And like Adam said, I'm not sure if I saw any come through in the chat. I'll check the chat, but
There is one.
okay, great.
Mike Swenson, I see you're still there. I don't know if you want to unmute. You had a question about non-competes. I don't know if
Yeah, Mike, it would help if you explained what you mean about not conflict of interest clauses post termination. Certainly it sounds like a non-compete. What is the nature of the conflict of interest that the manufacturer is trying to avoid? Mike, if you're there, you got to unmute.
He may be on the phone.
I know. I see him there, but it looks like he's on the phone.
All right. So then the answer, of course, will be zero benefit to Mike. But as we approach the question, well, I'm going to tell you what. Maybe we'll hold off on this. Does anybody else have questions? We can come back to Mike's when he's with us.
Yeah. Adam or can you hear me? This is Mike Gilmore. I unmuted here.
Yeah.
So I think the context is within a rep agreement. A lot of times they have language in there about having a competing line, right?
Sure.
But one of the questions that's come up with a certain manufacturer is, what if they try to restrict your ongoing business for 2 or 3 years after the agreement's been terminated? In other words, you cannot have a competing line, and they apply that not only during the term of the agreement, which one might accept, but for a period of time after the termination of the agreement, even if they're not paying you post-termination commissions.
Yeah, well,
is that a form of non-compete, and what would your views be on that?
Whenever a rep comes to us with a contract like that ahead of time, before it's signed, we always tell them that if a manufacturer wants you to sit on your hands and not ply your trade for any period of time post-termination, they have to pay you during that time period. If you're not going to get compensated, then you should not agree to any post-termination non-compete. If the agreement comes to us and it's already signed and it contains a post-termination non-compete, then a sharp employment-based lawyer like Adam Maxwell will look for ways to find how it can be rendered unenforceable. The idea that for a post-termination they're going to try and keep you away from business, I mean, it's somewhat, in my view, it's somewhat anti-American. The idea that you can't, especially as a sales rep, there may be some jobs, some capacities where it's more appropriate, but as a salesperson, to not be able to go out and continue selling after you change principal relationships, it's unholy. And we would look, depending on where it's based, you might have a better argument in certain states than in others to have it rendered unenforceable. Depends how it's worded. It's usually worded in a way where we can argue it's too broad. It covers too much. It's not, if you're selling widgets and the language in the agreement says that you can't work for a company that manufactures widgets, even if you don't represent those widgets, we're going to argue that that's too broad, that's just asking for too much.
And I think the other concept is where you talked about the post-termination payments, where, hey, any business that you've conducted for the last 3 years, you can continue to get paid for 3 years after termination. Would they have the ability to say, well, if we're going to pay you for this business, then we want you to not compete with our business? So it's a two-folded question, I think, Adam.
Well, that part of it, Mike, would require the negotiation. I mean, typically the agreements aren't worded that way, and they can't retroactively try and say, oh, well, you are getting compensated because we've agreed to pay you if there are commissionable sales. If the agreement is drafted in such a way that it ties the 2 points together, then it perhaps is more defensible. But those are not usually put together in the same agreement. They're really separate concepts.
Yeah,
So I don't know that that would work with that.
yeah, and this is not an existing agreement. It was more of a conceptual framework that we saw out there.
Okay.
So I think that's where the question Mike probably had came from.
I trust you, Mike, to represent Mike's interests, so I'm confident we've covered that. If not, Mike Swenson, then go ahead and shoot him down.
Yeah, I'm sorry. I had to take a quick call there, but yeah, Mike conveyed it well. It's a standard dilemma for rep. So if it's a small, medium-sized line, small company, very easy to say what you just did. This happens to be a large line with a extensive legal department that this may be a non-starter. So we may have a decision whether or not to take on the line over this. So it just makes it difficult, but I think Mike framed it well.
Okay. Well, you too have a large legal department working for you, Mike. So let us know when you're ready to call upon them.
You got it.
All
We're
right.
not quite there.
Okay. Do we have other questions? Anything else that we can help you with today?
I guess I'll raise one more, and maybe it goes to the last point on the FinCEN. I mean, we fell within an exemption, but I know a number of rep firms were concerned and maybe proactively filed. If you filed initially, is there any obligation to continue? Because it's not just a one-time filing. My assumption would be no, that there's no longer a requirement to continue filing.
That's right. That's right. Yeah, it's one of those rare situations where it was to the party's detriment to actually try to comply early with the law because it actually never went into effect. So, but those requirements, those reporting requirements, ongoing or otherwise, are essentially suspended for domestic corporations.
Adam Maxwell, I got a quick question. I was taking some notes when you talked about non-compete, and something else that's being looked at is non-something, and I forgot to write it down.
Yes, there's a variety. They fall under the restrictive covenant umbrella, but there's non-solicitation agreements, non-disclosure, confidentiality, and what we're seeing more recently are forfeiture for competition provisions.
That was it.
Yeah.
Okay, thank you.
No problem.
All right. I think we're going to close it out because we're at 3 minutes past the hour. Thank you, Adam and Adam, so much for this great session. You guys always do a superb job. There was so much valuable information here. So thank you very much.
Thanks for having us.
Yeah. Our pleasure. The recording of this session will be posted on the ERA Live section of our website and our YouTube channel within 24 hours. The next ERA Live will take place on Tuesday, September 23rd at 4:00 p.m. Eastern Time. It's going to be a very special session where we welcome Ed Smith, who will start as ERA's new CEO on September 1st. And a formal announcement will be issued shortly on that, so stay tuned. But the September session will be an introduction and a Q&A with Ed. So we hope to see you all there, and thanks, everybody. Bye-bye.
That's great. Thanks, everyone.
Thank you.